Hi, and welcome to this introduction to solving legal problems. This is your opportunity to apply all of the legal rules that we've been learning to real-life scenarios. Legal problems might seem a bit tricky at first, but most students come to enjoy them after a bit. I like to think of them as puzzles with more than one solution. For the purposes of this course, I'm going to ask you to use the IRAC method for solving legal problems. It helps you to break down the scenario I've given you and to analyze it in a logical way. There are 4 steps, and these are outlined by the acronym IRAC. The first is the I, which stands for issue. When I give you a scenario, you first have to determine what the legal issue is. And sometimes there will be multiple issues. In those cases, you'll treat each legal issue with a separate IRAC analysis. So what's a legal issue? Well, it's the legal problem at hand. It's supposed to be very concise, and you should keep in mind that I'm not looking for you to recite the facts of the case. Rather, I want you to identify which element of law is being considered. I'm going to give you some examples of these, and it should make more sense then. Next, we move to the R, and I want you to find a legal rule that applies. And so legal rules could come from legislation, or it could come from case law. If you were studying to become a lawyer, you'd be required to cite relevant legislation and case law. I'm not requiring this. Instead, I want you to cite the relevant case that we've examined or the textbook where the rule can be found. So even though I want you to give me the source of your rule, I am not requiring you to look outside of your textbook and your course notes to find the relevant rule. So you'll always refer back to the cases we've talked about or the textbook. After you've identified the legal issue and found the rule that applies, I want you to apply the rule to the facts of the case. And this could probably take a few sentences. Again, I'm going to show you some examples so you know exactly what I'm looking for there. Finally, you would draw a conclusion about the scenario that I've given you. So let's look at some examples of legal rules and then we'll explore some scenarios. Remember the list of cases I want you to know for each chapter? These are the ones that you need to consult when looking for legal rules. However, if we didn't discuss a relevant case, you can cite rules identified in the textbook. I've listed here some of the legal rules that come from our textbook or the cases that we've discussed. So the first one is an offer must be certain. All essential terms must be set out. So this is a legal rule. If an offer is not certain, then it isn't a legal offer. We didn't look at a case for this, so you can just cite the textbook. The next one is an offer can even leave certain matters to be decided in the future and still be considered certain. So remember we said that if an offer contains a formula to calculate the price of a good in the future, and we do this whenever the price of the product fluctuates, well, then that is still considered to be certain and still qualifies as an offer. The next one you'll see a lot of. Most advertisements are invitations to treat unless there is sufficient information and it can be accepted without further elaboration. So again, we didn't look at a case for this, so you would cite the textbook. The next one is revocation of an offer can take place at any time before acceptance, simply by the offeror notifying the offeree of the withdrawal. Again, you'd cite the textbook. And then the last one I have here is offerors can revoke an offer despite a promise to leave it open for a set period of time. And this comes directly from Dickinson and Dodds in 1876. You'll note that it is one of the cases that I told you I would like you to know. So let's take a look at a short scenario. Paul sees an advertisement for vegan bacon in his local grocery store flyer. It is on sale for a low price. Paul goes to the store only to find that the product has sold out. He tells the grocery store owner that they are in breach of contract. What is his legal position? All right, so you have the details of the case. You now need to use IRAC to analyze the case. That is, you're going to identify the legal issue, find a rule that applies, apply the rule to the facts of the case, and draw a conclusion. It's important to note that I'm asking you for one possible analysis. Think about a courtroom for a minute. There are usually 2 sides who look at a problem very differently. They will usually provide different arguments for a different conclusion. For example, one lawyer will argue that Bob, a fictitious Bob, breached a contract and owes money to the plaintiff, while the other side will argue that Bob didn't breach the contract and doesn't owe the plaintiff money. Because the law can be argued from different perspectives, you may not always get the same answer as I do, and that's okay. I'm looking for you to be able to identify the legal issue, find a rule that applies, and apply it correctly. As long as you do this, you'll be successful with these legal problems. Having said that, I'm not going to give you a lot of really tricky cases that could be argued solidly on both sides. In most cases, you'll be able to look at the scenario I give you and see which legal issues emerge, and the evidence will be pretty clear. So let's get back to the scenario. Starting with I, what is the legal issue in this case? I'm hoping that you identified the flyer advertisement as potentially problematic. If you didn't, don't panic. The more of these you do, the easier it gets. But I would say the issue here is this: was the advertisement an offer or an invitation to treat? Now, go look in your textbook or your course notes to see what we learned about these two terms. So we're looking for the specific rule, and we did talk about these in terms of whether advertisements constitute legal offers. You may recall that advertisements are usually not offers, but are merely something we call invitations to treat. The exception is if they contain enough information that the offer can be accepted without further negotiation or further information, then it could be considered an offer. We're talking about things like quantity available, time limits, that kind of thing. However, most advertisements do not contain that detail of information, and so we consider those merely invitations to treat. Remember, if there's no offer, there cannot be acceptance. Now, we didn't use a case to demonstrate this rule, so you just have to cite the textbook. Okay, so we've identified the issue as, was the advertisement an offer or an invitation to treat? The rule is that advertisements are not generally considered offers. They're considered to be invitations to treat. And now we need to apply that rule to the facts of the case. When writing these out, you may need a few sentences, but keep it brief. Here, the advertisement did not contain information about quantity available, the length of time the offer is open, etc. It was simply an advertisement. Now you need to draw a conclusion. Here, I would suggest that the conclusion is this: there was no offer. It was merely an invitation to treat, so therefore there is no contract, and if there is no contract, then the store is not in breach. Now we're going to look at another example. Pause the video here and take a few minutes to read the scenario. As you're reading it, try to identify what some of the legal issues might be. Okay, I hope you paused the video and read the scenario and gave it a little bit of thought. A good place to start is by considering what type of case this is. You can probably tell by the terms used in the scenario that this is a contracts case. Whenever you're working on a contracts case, start with determining whether an offer has been made. We know that this is the first requirement of a contract. So, could you identify the first issue as, was the advertisement in the trade magazine an offer or an invitation to treat? This is similar to the first example that we looked at, obviously. And so once you determine the legal issue, again, it's concise and it doesn't recite the facts of the case. It merely looks at the legal issue in question. Now we move to the next step. What is the rule about advertisements? So the rule, just like in the first example, is that advertisements are generally not offers, but are invitations to treat, unless it is comprehensive and includes all necessary information. We don't know how much information was listed in the trade magazine, but because it's about a consulting gig, that would be different depending on who the customer is. We would say that in this case, it was simply an invitation to treat. So we've identified the issue, the advertisement in the trade magazine. Was it an invitation to treat? In this case, it was only a generic advertisement in a trade magazine. And so we can draw the conclusion that the advertisement was not an offer. Okay, so first issue taken care of. What do you think the next issue is? All right, so we know that the advertisement wasn't an offer, but we need to keep looking to see if there was in fact an offer, because if there's no offer, there's no contract. The proposal sent by Sue seems an obvious place to look next. The second issue then becomes, was the proposal an offer? To find the rule, we go back to the textbook or our notes to see what a legal offer is. According to the textbook, an offer is a promise to enter into a contract on specified terms as soon as the offer is accepted. It's got to contain all information so that it can be accepted without further clarification. Okay, so we know what the textbook says a legal offer is. How do we apply that to the situation in this case? So we'd look at the facts of the case to see whether the proposal fit the rule. In this case, the offer contained all necessary information and signaled that Sue would enter into a consulting contract upon acceptance. Given this, what would you conclude? Because the proposal contained all of the necessary information for Sam to make a decision, and the proposal suggested that Sue was willing to enter into a contract if the terms were met, then a legal offer exists. Okay, so we have solved that legal issue. There was an official legal offer. So after you've determined that the first ingredient of a contract, i.e. an offer, exists, you can now move to acceptance. Therefore, the next issue is, did legal acceptance occur? The letter didn't reach Sue until after the deadline, which should cause you to stop and think. We learned that an offer can't be accepted once it expires. But do you also recall a special rule for items that are mailed? This is the rule you should be looking for. The rule in question here is called the postal rule. Acceptance occurs at the time the letter is mailed, if mail was the appropriate way to respond. So this is a bit of a tricky rule. It is mail, regular mail through Canada Post, is an exception in that acceptance occurs as soon as you put the letter in the mailbox. The same is not true with an email where acceptance doesn't happen when you press send, but actually happens when the person on the other end reads it. Anyway, the rule that applies here is the postal rule. So our second example is a bit trickier. This case is one where you could argue either way. So we're going to take a quick look at the facts. The offer was sent by email. You could imply from this that a proper way to accept would be through email. You could argue that Sue meant in writing to be email, and that given the offer was electronic and because the time period was short, regular mail was not an appropriate way to respond. If you argue that, then no legal acceptance has occurred and Sue can now charge a higher price. However, you could also argue that in writing can be interpreted as a hard copy with a signature, thus making regular mail an appropriate way to respond. If you decide this, then the postal rule applies and acceptance occurred when Sam mailed the letter, which he did in time. Therefore, legal acceptance did occur and Sue cannot raise the price. Your conclusion in this example is going to depend on how you argue the facts of the case. As long as you choose an appropriate rule and apply it correctly to the facts of the case, you'll succeed in completing the legal problem. Remember, you won't always get the same answer as I do. As long as you've identified the correct rule and can argue it effectively in terms of the facts of the case, you'll be just fine. The other two legal requirements for a contract, which you should know by now, are consideration, meaning both sides were giving something up, and intention, meaning they intended to enter into a contract if terms could be agreed upon. But these are not at issue. So, an offer did exist, and if you determine response by mail is appropriate, acceptance did occur, and there is a valid contract. Here are some things to consider when solving legal problems. Always start with the overall question and break your analysis into separate legal issues. If it's a contract scenario, start with whether or not offer and acceptance took place. After you've separated the scenario into separate legal issues, you're going to analyze each one using IRAC. Always provide sources for your rules, and for the purposes of this class, just the cases we've talked about or the textbook. You're not required to find resources outside of those provided in the textbook or in our course notes. You need to cite things appropriately. So remember that quotation marks and a full citation are required for material that is copied directly from the textbook or course notes. However, if you're paraphrasing, you still need a citation, but just the author and the year. Case names and year will suffice for citing cases in the body of your answer, and case names should always be in italics. Use the table of cases at the very front of your textbook for case citations that you'll put in your bibliography, and always use APA format for the textbook. When completing formal assignments, and there are 3 formal assignments, then I would like you to write it in essay format. So, for example, this case is about whether a binding contract exists between XX and YY. The first legal issue is. In a testing situation, I don't require that you be that formal, and you can just do IRAC and not worry about sentence structure. So now it's your turn, and throughout the course you're going to see opportunities to practice doing legal problems. Please take advantage of these, as you're going to find similar legal problems on tests and assignments. As always, please get in touch if you have questions or need clarification on anything. I am happy to help you work through these legal problems. It may be helpful for you to watch this video again once you've done another chapter or 2, just to come back and see if you are comfortable using IRAC.